Good morning, everybody. And we are now entering the 69th session of series sponsored by Lex Webinar, and in which myself and my friend Hemalatha are the joint hosts. It all happened in the month of April 2020, when nobody were even dreamt of meeting what is called a pandemic of this nature. At that time, the courts were closed. The world has come to a standstill, and young advocates were wasting their time. And at that time, we thought of doing something constructive over this technology and the forum called Zoom and other video conferencing sites. Thus came the Lex Webinar Series, and we have crossed 68 now. And as you all know, initially we were doing on daily basis, but after 31st of May, we thought of shifting only to weekends and confined to very important topics and very resourceful persons with good knowledge and reputation. So we are very happy to say that this webinar has gained momentum and has come to stay and has cut across the country's barriers. We have got participants all over the country. So what normally we do is that simultaneously we'll be live streaming it to YouTube or Facebook. And also we record the conversation deliberation and trim and post in the YouTube channel. If you see the YouTube channel, you will be surprised to know that so far the viewership of our channel is more than 1,60,000. So it is a number of viewers that makes all the difference. So they use this as an audio book whenever they are free enough. They can view it at any time if they are not able to see it online. Coming to the topic of the day, the resource person, the topic of the day is of much importance, relevance after the advent of a lot of UN Convention and Charter of Women's Rights. And the chief resource person of the day is Ms.Sheila Jayaprakash. She finished her law degree in the year 1981 and enrolled in the same year. And she joined the offices of the Doyen of the Madras High Court, Mr. N.C. Vatsamani. And she started specializing in family laws with much emphasis applied on laws relating to women and children. And she set up an independent practice of her own around 1989 and has been going strong since then. She is blessed with a son and daughter, and son is in US, and daughter and son-in-law are also practicing advocates. Ms. Sheila has been instrumental as one of the co-panelists in presentation of Charter of Women's Rights in India. She has visited countries like US, Brazil, and China in this behalf. And Ms. Sheila is the chairperson of the lot of committees and internal committees formed by private organization under the Prevention of Cruelty and Sexual Harassment in Workplace Act. And Ms. Sheila has been instrumental also in drafting the Protection of Women from Domestic Violence Act in 2005. And no wonder she has been an academician and has delivered a lot of lectures in various forums. This is the sweet and short introduction about Ma'am Sheila. And with this warm and precise, sweet introduction, may I hand over the forum to Ms. Sheila. Ma'am, you are welcome. The forum is yours.
Thank you. I have to thank you for giving me this opportunity to speak here. And that introduction, you know, when people give introductions like that, you wonder, are they really talking about me sometimes? Okay, thank you so much. The topic for the day is custody of children. Custody of children as an issue never comes to the forefront. It never arises unless there is a matrimonial dispute which accompanies it. And as we see, matrimonial disputes are rising. We had one family court in Chennai city. We have 8 today, crowded. They say they're going to start 4 more. So we see as these matrimonial disputes arise, as marriages seem to be breaking up, the cases of child custody also keep increasing. Child custody can be a main relief before the courts. If you file it under the Guardian and Wards Act, it comes as a case as a main relief. You could file it under the Hindu Minority and Guardianship Act, where again it's a main relief. But most cases come under the matrimonial reliefs as an ancillary relief. We see that when it comes as an ancillary relief, it comes as a branch of family law. Now, family law comes under a group of laws that we term personal laws. Why we call it personal laws is these laws run with the religion that you follow. You've got the Hindu Marriage Act, you've got the Indian Divorce Act, you've got the Muslim law, and you've got the Parsi law. Each one of them have different provisions for custody of children. So for divorce, for maintenance, for custody of children. So it runs with the religion that you follow. Of course, you do have the secular law like the Guardian and Wards Act or under the Special Marriage Act. It could be an ancillary relief under the Special Marriage Act. Now, I'm not talking for a uniform civil code, but sometimes, when we have all this confusion in the courts, I wonder, we have got, I think marriage and marriage alone is linked to religious ceremonies. Whereas all of the other reliefs, whether it is divorce, we don't have any religious ceremonies attached to it. So I often wonder, why don't we de-link these kind of provisions? You could have one law for common law, for adoption, for maintenance, for custody, and those kind of reliefs. But we fight shy of separating them. But it would be easier and it would be nicer. And I'm mentioning this because I don't know who's in the audience who may one day step in and bring these changes that we so badly need into the law. I mean, I wish you all the best when you start doing that. Now, why do we have these laws? What I would call the plurality of these family laws or the dichotomy of family laws. It's because when the British came and they consolidated laws, like the Evidence Act or Transfer of Property Act and things like that, they did not want to touch these personal laws pertaining to marriage, inheritance, divorce, maintenance, succession, adoption. So they just left this as a branch of law at the side and said, please follow what you've already been following. The Indian Divorce Act came into existence, today called the Plain Divorce Act, after the amendments. And we see that we have never changed it and we have left it like that. So we take this, when we take this as a dichotomy of laws, I am not going to go into provisions with you because, the time is short. So I'm not going to say under the Hindu Marriage Act, you can do this, or under Christian law, you can do this, because that you can get through a very simple reading of the provision of the law itself. I would rather stay and, bring out what are the guiding principles that the courts follow when it comes to custody. What is it that they would follow? What are the basic principles and how it does not differ at all as under the personal laws? We see that the Guardianship Act comes into play till a person is 18 years old. You have a guardian only till you're 18. After 18, you're an adult and that order ceases to be in effect. Unless you have got special disabilities, maybe a mental disability or some kind of disability, which then prolongs or under which disability, the guardian, the act, the law, the order that was passed continues to stay in effect. So we see that we have a common principle for all cases. And what is the principles that should be followed? We see that courts should be very sensitive. Lawyers, and when I say courts, I mean all the officers of the court, whether it's the people who come in, the judges, the lawyers, the conciliation, mediation, the counseling that we have when it is a custody case. Because what happens is, you are dealing with the rights of a person who is not before you. The courts are making decisions about a child, and the child is not before the court. If the child is brought to the court, it's for a very short period, 1 hour of a 10-minute meeting with the judge. So what happens is we are making decisions about things that affect the child profoundly. You are taking a child from a home, handing it over to one parent. And sometimes what I find very disturbing is when children are separated. We'll come to that later, that when you have stayed as a family and you have a brother, siblings, and suddenly one child is with the parent, mother, and one child goes to the father. I'll never forget the case that happened right in the beginning when we started family courts and we had Judge Krishnamurthy. Children, one was with the father, one was with the mother. When they came to court, they were little children, maybe 5 and 7 years old, or 5 and 6 years old. A brother and a sister, son with the father, child with the mother, the daughter with the mother. Court calling work started. Both of them walked to the front, sat on the steps that the judge goes up, and kept talking to each other, laughing, talking, holding hands. And the judge was sensitive because when the court officer said, no, take them away, he said, let them sit there. And for about 1.5 hours, they were holding hands and talking. And I think that made such a profound impact on me that I always think that when it comes to custody of children, sensitivity is what takes us through, because you have to think of what this whole procedure, the way it affects life. Now, when we see, I would like to stop here for a minute and maybe look at what these words mean. We come across guardianship, we've got custody, we've got visitation. That becomes the 3 compartments under which you can look at under this law. So what is guardianship? Guardianship pertains to the legal aspect, okay? The authority, the legal authority to make decisions, legal decisions for the child. Custody pertains to the physical custody. Physical custody, guardianship, legal custody. Custody per se, physical custody. And somehow the courts have always worked that the mother as a nurturer, as a caregiver, usually custody is given there. There are changes today, but earlier on, it was like only the mother could have physical custody, only the mother could look after the child, only the mother can be the caregiver of the child. Oh, that is changing. The primary caregiver, let me use that word rather than just caregiver, the primary caregiver, yes. I would say in some cases, the mother as the primary caregiver is the only person who could do it. But we cannot hold that as a golden standard and say only the mothers can be primary caregivers. What is child access? The last one, visitation, is the parent that does not have custody. How will they have access to the child? Under the personal laws, we see that the father is under every personal law. The father is the natural guardian. But we see that access to the child does not depend on that. It is separate from that. We see courts spend a lot of time on deciding the custody issue. There is evidence, it goes on almost like a main case where you settle custody after a lot of consideration. But visitation is usually just like that, almost like over the counter. Visitation, okay, you see the child, and suddenly a parent who has been a mother or a father 24/7 finds that they can have access to the child every 2 weeks for 2 hours on a Sunday afternoon in a public place or in the family court creche. I think that's devastating for some parents and for some children also. But there's nothing that we can do about it at this time, because even at that stage, when you have such a little access to the child, we see that the parent who has custody of the child does not give you even that access freely. If the order is X can take the child, father can take the child out, invariably the child is accompanied by the mother. We see this over and over again. Another place where we have a lot of these custody orders, not custody orders are not flouted as much as visitation orders, is when you have got a mutual consent divorce. Invariably, the person with the child wants the divorce. They say, yes, you can have the child half the vacation. You can have the child. Very, very, broad-based guidelines for visitation are laid down. Once the divorce is through, you don't follow it up. What happens? Does the parent who loses the child, do they have to go for a contempt case? Under the law, visitation is ongoing. If you have a mutual consent divorce, the divorce is closed, the maintenance is closed. But what is not closed perpetually or indefinitely or completely is the question of the custody of the child. That remains open till the age of 18. But in spite of that, what happens is courts are, once it's a mutual consent divorce and only this order of visitation is being flouted, it's extremely difficult to approach the court and get an order, and that order changed. Because invariably they come with the petition saying, give me custody and I will give visitation. Some of those petitions, by the time they're over, the child is also 18 years old. So it's something that we really have to think about, what to do when an order of visitation is flouted. We have to really take that into question and think about it and see what we can do. Now, if you come to the question of custody, we find that before I leave this, we do not have child psychologists in the court. I think at this point of time, it is important that we should have experienced child psychologists who can talk to children, find out really what they want, not a 5-minute or 10-minute appearance before a judge, but more to find out what would be best for the child. Because when we move on to the next area, we find that the law has shifted, and it shifted a long time ago, saying that if issues of custody will not be based on the rights of the parents. So it's not my father's right, the father's right as a natural guardian, or the mother's right as a caregiver, or as a primary caregiver, nurturer that comes into play. What comes into play when we are talking about custody is the rights of the child. What is in the best interest of the child, and what would be the correct thing? What would be in the interest of the child? Where to stay? How often to meet the other parent? So it is the best interest of the child. We see that the very first case came up in 1973, Rosie Chakramangal. If we could have that on the screen, maybe it would be good. Now, in this case was the first time when they said that what should be determined, what consideration for determination is the welfare of the children. So this in 1973, the Supreme Court said, it is the welfare of the children which is of paramount interest, which should be which forms the basis of this kind of order. And it has followed right through till today. This is almost the Bible for custody case, this case. But again, in this case, the only problem I had with it personally, though all the basis, all the rule, everything is a firm foundation. But in this case, there were 3 children. The daughter and the youngest son was given to the mother, and the middle son was given to the father. And like I said earlier on, to me, it is a little difficult to say that this kind of this kind of order where the children are separated is traumatic for the children. They have lost a home, parents have separated. Do you have to separate them also? To me, becomes a very basic question. This has been followed throughout, right till this year. It is also followed in another case where you have, again from the Supreme Court in 1987, Elizabeth Dinshaw versus Arvind Dinshaw, where when a question arises pertaining to the custody, I think we have that also on the screen if anybody would like to read it. Yes, it is Elizabeth Dinshaw versus Arvind Dinshaw. Correct. Yes. The next one.
Share Elizabeth case.
Yes, Elizabeth case is there. Also, the court has re-emphasized when a question arises before the court pertaining to the custody of the minor child, the matter is to be decided not on the legal rights of the party, but on the sole and predominant criteria on what would serve the best interest and the welfare of the minor. Best interest and welfare of the minor. This again is a Supreme Court judgment of 1986. So we see this emphasis on welfare of the child comes right down to 1920. We've had this sentence repeated over and over again. What would serve the best interest of the child? What would be yeah, there we have it. If we could go up a little bit, sir, you would see that the paragraph where it says it is the welfare of the child. Yeah, a little bit more. Yeah. Yeah, that's it. I think that would do. This again has other ramifications of international custody, but we'll leave that for the minute. So you can take that off. So thank you. Okay. So what we are looking at as this, not as a substantive provision. In India, we do not have the concept of joint custody. Many countries have the concept of joint custody. It's a little difficult, I suppose, to enforce or how. But custody in many countries around the world are so strict that the parent with custody can never move beyond 100 kilometers or 50 kilometers of where the other parent lives, where the order has been given. It's so locked down so that the children have almost equal access to both parents. Because today, child psychologists are very clear that the children need access to both parents to be able to grow up in an atmosphere that is conducive, in an atmosphere that gets closest to what they would have had earlier if they have access to both parents. So if the parents are forced to live together, near each other, then this kind of order can easily be enforced. Then we see that before I would like to move away from this custody and guardianship of parents and what is custody and guardianship and visitation, as we finish these definitions, I'd like to talk about one more group of people whom the court and the law has never recognized. That group are grandparents. We have absolutely no provision of law to say how grandparents can access children. Grandparents, I know the law is already rolling its head between mother and father. Why do you bring grandparents into it? But as a grandparent myself, I know how wonderful, how wonderful it is for children to be with grandparents. That if you're talking about the best interest and welfare of the children, you also have to take into account the way the child can meet, interact, and move with the extended family of both parents, especially with grandparents. But we do not have any law for that. And what happens is grandparents not only miss out on their grandchildren, they become the victims of their child's marital discord. One whole generation it moves. So your daughter has a problem with her husband, or your son has a problem with his wife, and you as one generation behind gets caught up in that. You become a victim of that discord because you lose access to your children. Now, this has been highlighted. It's not part of the law, but it has been highlighted. Justice A.P. Shah, when he was chairman of the Law Commission, 257th Law Commission report, he has made it very clear that we need reforms. This is, again, people who are going to work tomorrow on changing the law, take this down, that we need a reform, a change in the law, because Justice A.P. Shah has highlighted it, saying reforms for guardianship and custody laws. There is a need for changing the current practices because we give supremacy to one parent. The parent who's got custody has got supremacy, can control the parent access of the other parent. And he thinks that's bad, and I totally agree with him.
Can you just say the number of the report?
257.
257.
Yes, 257.
Thank you. Thank you.
I'm sorry if it wasn't clear. He has proposed joint custody, but joint custody, like I said, is something that would have to be worked out very, it needs a lot of finer details and finer tuning. And the Law Commission also sent recommendations to the government in 2015. It was draft law was sent, but I don't think it's ever been brought out. It must be collecting dust in some corner of some office somewhere. But I like the sentence that Justice A.P. Shah uses. And so I am going to read it out to you. He says there is disparity in importance given to one person, okay? And so he says, in the principle of welfare of the child, relating to guardianship and custody, the fiercely fought custody battles, there is no way to ensure the interest of the child is actually protected. So what he is saying is, even though we keep saying it is the welfare of the minor, it is in the best interest of the minor, he has pointed out when this custody battle is fought so fiercely, there is no way that any court can really ensure that the interest of the child is protected. That's a little sad, because here we are saying take in interest of the child. Yes, Supreme Court has said it. We are so happy about it. But we see that practically, when we come down to the level of enforcing these laws, or how it affects the child, Justice A.P. Shah is right in saying that there is no way to ensure it. Now, before we move on further, I want to talk about another group of people. You see, in India, we've had people move up all over the world. And husbands and wives, whether they live in India, move from India, lived across the world, face the same kind of problems. And many, many cases of Indian couples who moved from India, went to foreign countries, have got problems. And there is one more dimension added to these problems in what we call transatlantic cases. Way across the Atlantic, way across this Pacific Ocean, we've got these warring interests. And again, even there, caught in between the warring couples is our children. There also, children face these fiercely fought battles. We kind of think, yeah, in a foreign court, maybe it's not fought so well, bitterly. It is fought very bitterly. We see in this kind of cases, there are different scenarios we have to look at. The child may be ordinarily a resident of the US, UK, Australia, Japan, but one parent comes back to India with the child and files a petition under the Guardian and Wards Act. Then what happens? The law starts interpreting on ordinarily resides, because the Guardian and Wards Act is very clear that the jurisdiction rests on where the child ordinarily resides. So the mother or the father say, no, the child is ordinarily residing in India, but the child has been brought from a foreign country where maybe the child has lived for 7 years. So this question of ordinarily resides gains a lot of importance in these NRI cases. Secondly, that's the first scenario. No case abroad. You brought the child away to India. Can you start the case here? What happens? Another scenario is that you have a case going on there. You have a case which is completed there, but you flout the orders of a case. Let me say, a case is going on there. You have got a custody case going on. And in the course of the case, one parent brings the child to India. Do you send that child and the parent who has brought the child here back to finish the case in that country? Or do you let that case lapse and continue with the case in India? Allow them to start a fresh case. And we've also got to remember, in these kind of cases, one parent is there in the foreign country and one parent is here in this country. So what happens in these kind of cases? Then we see the third scenario would be, you have completed the case. It could be a mutual consent case. It could be a unilateral case where the issue of custody has been settled. Very, very fine drawn out plans for access to the child. And the child lands up in India. The parent who's got custody could run away with the child and bring the child to India, depriving the other parent of custody. We've had cases, that's more common, but we've had very rare cases of when the child goes for its visitation. We've had a case where from Texas court, in a mutual consent case, the child was brought to Chennai, handed over to the father in a 5-star hotel, and never seen again for 5 years, till the child was old enough to get in contact. So we see that we have all of these, a whole range of scenarios that comes from NRI cases. Now, at one time, yes, when they came here, we see that the Indian court said, the child now ordinarily resides here. There's no case pending anywhere else. We will take up the cases here. But as we come into these later cases, we see that the court is of the opinion that when the case has been decided by a foreign court, and all that is remaining is how one parent has access to the child, we should send the child back with the parent who has custody to the country, to the court which passed the initial order. So you send the child back there, and then finish the case there. Now, the foreign courts, when you have children brought out like this, in Indian law, we still look at it as legal custody. The mother had custody of the child. Yes, she took the child away from there and brought the child to India. And now the father has no access to the child. We say that the mother's custody is still legal. So, that colors the whole perception of what is happening. Whereas in the Western world or other countries, most other countries look upon this as abduction. Abduction becomes a criminal offense. You had no right to lift. You could be the mother, but you still had no right to take the child from that court, from that jurisdiction, and totally deprive the father of the fruits of an order that he has received, or father or the mother. Now, one reason why we see this kind of swinging difference in the way we look at these cases is because India has not signed the Hague Convention, the civil law on abduction of children. So when we have not signed the Hague Convention, we tend to look at it from a different perspective than countries which have signed the Hague Convention. Yeah, we keep on. Now and then the question comes up, and India, yes, we are going to sign the Hague Convention. Now, recently, there was also talk that India is going to have a new law for these kind of cases involving NRIs. And we would have a new custody law for NRIs. I don't know how far that's going to work. Can we not use the law as we have it? Can't we use precedent as we have it? And still give a finality to these cases. But these are things on the anvil. A new law for NRIs and custody, India coming forward to sign the Hague Convention. But while it is still there, we have this, the case that has come up now, what I would say almost the case which is of prime importance, because the Supreme Court, can we have it when I'm still talking? It is the Ravichandran. See, in Ravichandran's case, what happened? This is an NRI case where parties both lived in the US. They approached, I think it was the state of Texas, where they approached a court where they came to a mutual consent divorce, where the mother was given custody of the child and the father would have access to the child. The mother took the child and came to India. It's not that she just came to India. She went underground in India. And for 2 years, the father knew that she has come into India, but where she was in India, what she was doing, he did not know. So he filed a habeas corpus petition. The mother, when she knew she was going to be tracked down, would take the child and move to another place. She managed to hide for almost 26 months from her husband, from the courts, from her family, depriving the child of basic education also. But anyway, the father never gave up because he also followed. He had Interpol, he had a host of people trying to trace. And the child was found in 2010. The child was brought, and the Supreme Court said, when it comes to cases like this, where there is a finality of orders in a different court, in a different country, do we even have to go into the merits of the case? And I thought that was, it's a very broad aspect, a judgment that takes a lot into consideration. It's a good judgment to read because it goes into a lot of details and then says, do we really have to even say who has rights to the child? Where is the welfare of the child? Do we get into the question of in whose custody or how the other parent should have access? Or do we just take it as a summary proceeding and say, bringing the child into India is not correct, so take the child right back? And of course, they did make it convenient for the mother to go back. You read the judgment, it says, you take the child, the father will withdraw all kinds of criminal action against the mother. He has to give an undertaking that once the mother goes to the US, the child will not be taken away from her and given to him, and she gets locked up because of an abduction case filed there. They also said that he will make provision for the mother to travel to the US, make provision for her to live there, to stay there. It was a kind of broad-based comfortableness that was made rather than being purely technical. It was, I think, justice tempered with a lot of mercy to it, and it was not purely a technical question of you have to go back, face the music there. There is one more case also where, yeah, we could have it on the screen also. It is Chandrakala. Chandrakala.
It's there, ma'am.
Yeah. Chandrakala also had, yeah, thank you. Chandrakala was also a 93 case. A lot of the principles followed come from Rosie Chakramangal's case, Jacob Chakramangal's case, where they say best interest of the child, welfare of the child. But here also we have got that element of father living in India, mother living in the US. The other case was mother came to India, father had a job, worked, lived in the US. Here, even though the father lived in India and the mother lived in the US, custody, they thought, is in the best interest of a growing daughter to be with the mother. And above all, the child was not very young, could answer questions, could make choices, which maybe did not say that you would, I mean, it would not sway the court completely, but gives a lot of weightage. The child was living with the grandparents in India when the father said he lives in India, he wants the child. The mother was ready and willing to take the child with her to the US. We have to remember that most of these children are also citizens of another country. They're not Indian citizens, but India still has that hold over them because one parent lives here. Here also the courts went into detail and just didn't say, give the child to the mother. She keeps the child. Child is an American citizen, and stop there. Instead of that, they got an undertaking from the mother that the child would be sent at her cost to India every year to spend at least a month with the father in India so that she could interact with the people in India, the culture, the tradition, everything to be here. This was also followed very, very on similar lines with a very detailed report in a judgment of Justice A.P. Shah in not reported case where the cause title is, if anybody wants to see it, is Bobby Matthew versus Ajit Abraham George. I've not given it there because it's not reported. It is a judgment in OSA 75 of 2006. His lordship again has gone into great detail of the principles of the law in relation to custody of a minor. So if we want to read that, it is in OSA 75. So we see that what forms the basis of these orders? Interest and welfare of the child. Now we've got a little bit confused when we see that with all these fought battles, interest and custody does not play such a predominant part. Do we need laws, more laws, or do we need to refine the laws we have? Okay. Before we leave this topic, I just want to touch on a few other laws which also have custody. They're not personal laws, but they do relate to custody of children. One comes under the Mental Health Act. You see, the Mental Health Act, when you are appointed a guardian under the Mental Health Act, it's not going to stop with 18. You know, today the Mental Health Act is gone. We have got new laws in place, the disability, the whole shift in the disability laws. And you have moments of lucidity where a person can give advanced directives, but still we do have appointment of guardians. Very, very limited, totally changed from what it was prior to 2017. You now have a board, it doesn't come to court. The board has an authority, just like the Juvenile Justice Act. The Mental Health Act has a board. Juvenile Justice Act also has got provisions for dealing with children. But here it is in two aspects. They deal with children who are in conflict with the law. They deal with children who are in need of care and custody. I'm not going to go into great details because there, again, it is a board which makes the decisions, a board which comes out. But once there is a case pending in the court, we have to remember the Juvenile Justice Board cannot make decisions on its own. It cannot take a decision when it is the court that makes the decision. There's one more law, the last law, that is the Protection of Women from Domestic Violence, PWDVA, which also has got a provision for custody. It's not a personal law, it's a not a matrimonial law. It is a matrimonial law. It comes along with a breakdown of marriage. But here, the case is filed you have a whole procedure of it where you have a social welfare officer, where you try to settle the questions before you enter a court. And if you're not able to enter a court, then you come into court where the issue of custody can be settled, not by a civil court as it is under the Guardian and Wards Act or the personal laws, but it comes under the criminal court. So we see that we have a range of provisions, we have a range of kind of orders that are passed, and now we have a range of courts that deal. Guardian and Wards Act, you have concurrent judgment. Jurisdiction, you can file it in the High Court, you can file it in the Family Court. It is not derogatory. The Guardian and Wards Act does not take away from anything from the other laws. So you have a range of laws that you can choose to file your petition under. There is a range of courts and court jurisdictions under which you can file this case. But wherever you file these cases, always remember that the child's welfare is of paramount interest. And as lawyers, we also have to keep in mind, whether it's in the court of law, whether it's at the mediation table, we have to have in mind the welfare of these children who are not in the court or sitting across the table. Thank you.
Thank you very much, ma'am. I expected an interesting and enthralling session, but I would say that my expectation was less because you did something extremely well. From the practical perspective of what a parent who is worried, though they have division between themselves, they have a common interest of their children's interest. That is the biggest casualty when the couple are separated. I hope this will be a lesson for the advocates more than the parties.
Hope so too.
Because I could see that in most of the cases, advocates becomes perpetrators of some of the issues.
I think because you identify so much with the clients, so you tend to do that. And on top of it all, I would say that the issue of custody sometimes, it's so acrimonious, the way they fight over a child. The child is a pawn in the fight. And I often think if you could settle the issue of custody in mediation, if you could settle the issue of maintenance, if you settle these two issues, the rest of the issues pertaining to matrimonial disputes just fall into place. It's used as a pawn. I'll get back at you. You will never see the child again. I won't show you the child. That's the punishment.
That's the punishment.
Yeah, that's it. So we have to kind of bring that down.
In some of the cases, when you see the child is brought to the court for the purpose of ascertaining willingness and preference, mostly some children are being tutored by the person in whose custody the child has been for a long time. Maybe it is a father, maybe it is a mother. So judges are able to understand the child has been tutored to say something against, they spit venom against the other side. how to deal with such situation, because the child yearns for the departed parent, either father or mother, but the person who is having the custody of the child for a longer period, they poison the mind of the child. At times, the court is not in a position to do anything because the preference of the child is otherwise. So the husband or the wife, they only want the money or education expenses. They don't want the child to be given physically for custody. Where lies the problem?
Yeah, you're absolutely correct on that, because that's what really happens. But I have found that a lot of the judges don't really talk to a child. That's very heartening. When we have these child custody cases and children are brought to court, I have found that they leave the parents outside. They try to talk to the child alone. They talk to the child and don't come out with questions like, do you want to go to your mother? Do you want to go to your father? I've heard that question, and I think it's very wrong to ask a child to choose between mother and father. But usually they sit, they talk, and say, which school do you go to? And that very slowly they bring out how the child is. Is the child well looked after where she is? I think the length of time a child has been with one parent also counts a lot. That is there. And sometimes when you have children, they tend to speak the truth, sir. We kind of think they're tutored and they're brought. I had a case where maybe the girl was about 5 years old and the boy was a little older, tutored by the father and brought to the court. And when the judge, that was one case where the judge said, do you want to go to your mother or father? That was a wrong question. Had mother and father, both the lawyers, everybody is there. And the little girl said, I want to go to my father.
Oh.
I want to go to my father. And then the judge asked the next question, but why do you want to go to your father? Daddy said, if I say I want to go with him, he is going to take me to Singapore for a holiday. That was the next answer. So, if you really take time to talk to them, maybe the tutoring wears off and you do get to the truth. I hope so.
I understand. In a case recently, which I think I handled at Madurai bench, a divorce case actually filed by the wife. And I understand that the divorce was not granted. And in the same case, another case was tried together for custody. The custody was also ordered to be handed over to the father by the court. So two appeals, one appeal against omission on the part of the court to grant divorce. Another case against a decree whereby the wife is directed to hand over the custody of the child to the father. The child is a girl around 7 or 8 years, very innocent. And when I met the child in the court, I could see that she is longing for the love of her father. But because of the understanding being lost between the parents, the child was not able to talk to the father. But fortunately, the mother was not so cruel as we see in the television serials. So along with judge, we sat with the counsel for the other side, and we made both the spouse to talk together, spend hours together, and understood that the child wants the father's love not to be denied. At the same time, she wanted to stay with the mother. So what we did, we paved way for interim custody on every festive occasion, whether it is Diwali or Pongal or New Year or Christmas or Puja holidays. The child will be allowed to stay with the father for 10 days continuously. And the mother can talk over the child over WhatsApp, phone call, video calls, and the technology has now, like this, has developed. And every Sunday for 1 hour, the child can talk with the father over WhatsApp call, and the child will be with the mother. Who knows, after 1 year or 2 years, they may even get united. So where the role of the courts was very important, and the judge was very patient. The judge was a female, able to understand the love between the father and the daughter. And we advocates also cooperated. The counsel for the side who was appealing for the father was very cooperative. My client, who is the mother, was able to understand what could be the trauma the daughter undergoes if the daughter is not able to feel the love of the father. As you know, love of a daughter over the father is something unfathomable. There are cases in which the parties' cooperation and judges and advocates as a team. So in such cases, do we need any amendment in the Act to see that these kind of situations are handled well?
That's what I said, sir. The law is there. It's got everything. That's why I started it saying
Sensitive. Yeah.
Sensitivity. What you all had was sensitivity. Parties were also sensible. Okay, they were willing to. Sometimes we've had judges who are extremely sensitive. I know in the family court once the child would not leave the mother, was just holding the mother's sari and burying the thing, not going to the father. The judge said, ask the father, you just go upstairs. Go to the first floor and wait in the first floor corridor. And then he told the mother, sit there in the corner. He called the child, sit in the court, called the child, took the child to the chamber, spoke to the child, and then quietly sent the child upstairs to the first floor. Oh. I was on the first floor with my client. You will not believe it. As the child came up the steps, child kept looking back to see whether the mother is there, and then ran and hugged the father. So, I think somewhere we should in the counseling bring out to the parents how detrimental it is to the welfare of your child, physically, mentally, if totally deprived of one parent.
So that part
is something I don't think you can bring that in by law.
Yeah.
It's there. It's something that has to be, come out into the open, come out through counseling, come out through, where parents see the approach, which is really good for their children.
So we need to sensitize them, then bringing more laws.
Yeah, sensitization. You've got counseling, you've got mediation, you've conciliation, you've got the whole works. So somewhere.
But the counseling system, I think court must be a permanent body or a continuous process. Sitting for 1 hour or sending them to outside a counseling center. Why don't you have a permanent counseling session in the high court campus itself? At least in district level.
We have counselors change. It's not a very good system that we have in there. We do have a system, but I don't know how effective it has been. People who really have the mind to settle. People who want to fight never do settle.
Whoever counsels.
Yes, whoever counsels. So that attitude, that change would have to be worked on.
Okay. Here, Mr. Raghavan is waiting on the line. He wants to talk to you regarding a doubt. His question is, he has texted in the chat box. I think the cases referred are, that's what we have been discussing, are from the educated elites. How about the trend in semi-urban and in rural India? Kindly share the experience. That is the question.
In my experience, I think it is the educated classes that fight so much over children. It's sad to say that, but that's it. I have found that as we don't have that many custody cases as you come down. I shouldn't say come down. As we move to another strata of society, I apologize for using the word come down. As we move to another strata of society or semi-urban, semi-rural, I think they have more common sense. And they're more guided not by the laws, but by common sense. And we've never had that much of a problem. I've not practiced too much in rural or semi-urban areas. It's more in the city of Madras, but we have different people in the city of Madras or in Bangalore or wherever else I've gone. But we see that, I have seen that the educated class, mothers working, fathers working, IT, bank officials, they're the ones who take this fight of custody of children to the very extreme, right out to wherever you have to go. That's it.
Okay. Ma'am, there is a question.
I hope I've answered your question, Mr. Raghavan.
Yeah, yes. Okay. You have answered it and you hit the nail. And there is one from, I hope she's from Mumbai, Ujwala Kadrekar. Ma'am, you can talk to Sheila, ma'am. Ujwala, ma'am?
Yeah. Can you hear me?
You are from Bombay? Are you from Mumbai?
Yes, sir.
Yeah, I remember you. Come on.
Yeah, thank you so much, sir. Yeah. Hi, Sheila, ma'am. Ujwala here from Lawyers Collective. I hope you remember me.
Of course I do. With Indra Jaising.
Yes.
Nice to see you.
Yeah. Where is your video?
Where is your video? Video? Video. 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 Video.
Oh, no, I don't want to come on video. I'll just talk to you. This is Sunday morning.
Okay,
Yeah.
I understand.
Ma'am, actually in this lockdown period, in fact, I happened to do some cases under Domestic Violence Act. And as you rightly pointed out, I happened to give custody in 3 of my cases during this lockdown period. And especially where the mother was thrown out of her matrimonial home, and we had to put her in shelter home and then to her parents. So of course this was not a custody battle per se, but as you rightly said, the sensitivity of the judges is definitely something that we really want to harp upon. And lately the cases that I have seen in family court, where I have seen that the mother has already separated from the husband, and the child is especially during separation, the child was just few months old when the separation took place, and by the time the divorce took place, it was the child was almost 2.5 to 3 years. In the given scenario, the child, of course, you could not even talk to the child. The judge could not talk to the child, but the father was fighting the custody battle, and he sought custody, and the child was just 2.5 months, and without even getting into the, I think, into the details of the case, not even assuring that the child has never been with the father for all this while, still gave the not custody but access to the child of 15 days post the judgment, post the order, that the child should go and stay with the father for 50. This was just 2.5-year-old um, child. And of course I challenged it, and finally the court said no, the parents have to undergo counseling and all. But I just want to say how even the courts are looking at custody orders. This was one question. Just I think right
Can
in the,
I answer this question first?
yeah, please,
Then you can
yes,
ask me the
yeah,
next, otherwise
yeah,
it gets
yeah,
confusing.
please.
You see, that's where again the issue of sensitivity comes in. You don't, just because the child has been with the mother for 2.5 years, does it mean the father can never have the child?
No,
I
never.
think we should be able to have staggered orders.
Yes, yes.
Where the father first meets the child at a common place.
Yeah.
Maybe with the grandmother, if the mother doesn't want to come. Somebody that knows the child.
Absolutely, absolutely.
Absolutely.
Yeah.
And then the father gets to know the child. I've had cases like that and I have found that in these kind of cases, meeting them in a mall or someplace is really nice, because the child then gets drawn into these games, and it's not a concentrated thing of sitting and talking to the father. 2.5-year-old child cannot sit and talk to anybody.
Yeah.
But if you could take the child and show, here's some games, some little swing the child sits on. It is a long process.
Yeah, absolutely.
A long
absolutely.
process where the father builds a bond with the child, maybe till the child is about 4 years, 5 years old.
Yeah.
Then you have to again stagger it. Take the child from morning to evening. Because, I don't understand giving a child, even a 6-year-old child or a 7-year, unless the child is really, really comfortable with the father. No child of 4 and 5 stays in the other parent's home overnight.
Yeah, right.
It becomes very difficult.
Yeah.
You'll have to stagger it again. Start from 8 in the morning to 8 in the evening. And then after another year or so. See, it is something that everybody has to invest time in.
Yeah, later I got the staggering order in this case. And where basically in our family court, we have this access place for custody cases. And so the parent the father could spend some time in the access room along with the counselor, all in place. So definitely a staggering order, but I was just thinking, how is it that even courts are not being sensitive in passing this kind of orders?
That's true. Absolutely insensitive.
Second,
I have one small problem with the counseling is people visiting children in the creche. On Saturday morning, if you go to the creche, everybody's given an order of visit in the creche. So you have a crowded room with mothers and grandmothers sitting outside and biting their nail and looking to see whether you can look at the child, attract the child.
Yeah.
The father's trying to pull the child into one corner. And you've got about 20 children, some happy, some crying, some,
Yeah. Yeah.
a very nice
No,
atmosphere for children at all.
absolutely.
You're going
Absolutely.
to visit your mother, you're going to visit your father. In a room full of crying children, no games, no toys. I think we have to also change that a bit, that parents could, I don't think, have it in place that the parent who's taking the child cannot run away with the child,
Yeah.
would not do anything to the child.
Mm-hmm.
You see, I always think this way. If your marriage hadn't broken up, you would have trusted that man with your child.
Yeah.
Huh?
Absolutely.
Since your marriage broke up, he's a bad man. He may do something. He'll do this. He wouldn't have done it if you lived together.
Yeah.
He won't
Very
do
well.
it when he's taking the child alone. Let's
Yeah.
have that faith, unless
Yeah.
you can prove otherwise. Unless you can prove otherwise, where you need extra care.
No, I think custody matters we really need to evolve with strategies, and they really need to be handled more carefully and more cautiously. And yes, during this lockdown, again, I'm sorry, but this is again one grandfather has approached me, and so his 22-year-old daughter has committed suicide, and she has at the time of her death, the child was just 10 months. So currently, the child is 1 year 3 months old, and so the father and the father and the grandparents, the father's parents, they were no, of course they were out on anticipatory bail, but the grandfather of this deceased girl has also filed a custody case seeking custody of this grandchild. Now here again my problem is the child has never stayed with the girl's parents, and in the given scenario, because they are out on anticipatory bail, we don't know when the hearing is going to start and all. But here again, can the the girl's parents, deceased girl's parents, can they claim custody of the child?
I think, Ujwala, you brought out a good point, which I should have touched upon. That is when grandparents come in for custody.
Yeah.
Grandparents usually come into this custody scene where, in cases like yours, and we have so many of them,
Yes.
where when the girl commits suicide, and especially when the child is very small, like you say, 2 years, 3 years within that, what happens to that child? In many cases that I have seen, they kind of work out some kind of agreement between them. You don't press charges for criminal case, we will give you the child.
Yeah.
A lot
Yes.
of them work it out that
Negotiation.
way.
Yeah.
You don't press criminal charges, you say that it was suicide, we'll give you the child. The maternal grandparents are very happy to have the child because it reminds them of their daughter. And they always say, what do we gain by pressing criminal charges? Daughter is dead, she has gone. Okay? So why not take my daughter's child and bring it up properly? Nicely, at least some kind of ardor, some kind of it makes us feel better. That's what they say. But I've had a case where when they wanted to barter this, the maternal grandfather came to me and said, I didn't even look at the child, because if I see the child, my heart will melt. The child is only 1 year and 3 months old. And he told me in Tamil, he said, நான் பெத்த புள்ளைய அவன் கொன்னுட்டான், அவன் பெத்த புள்ளைய நான் எனக்கு வளர்க்கணும். That is, the child that I bore, he killed. Why do I look after the child he bore? The whole thing is different people react differently, but there's nothing in the law which says that the maternal grandparents cannot ask for the child. But I think that in custody cases, whoever's got custody when the whole thing starts, sometimes a lot of it, that plays a very important part. There's nothing in the law to say that the parents of the girl, maternal grandparents, cannot ask for it. They can.
Yeah, of course we have claimed. I don't know when that decision will come through, but yes, it is.
Yeah, it's going to take time.
And of course, you already pointed out that gap in the law. That grandparents have no say when it comes to custody. Yeah.
Yeah, but in this kind of cases,
Yeah.
they do have some stay.
Yeah, of course.
But always it's the father who's there already. There's one parent alive.
Yeah.
So there's always the aspect of when there's one parent alive, grandparents don't have a say. Sometimes both parents have died in an accident. Both grandparents are again fighting, something like that.
Yeah. Yeah.
I think in these kind of cases, like you pointed out, the person who's had the custody for a long, long time, with whom the child is more comfortable, somehow they seem to come out of it with custody.
Yeah. Thank you. Thank you.
Okay.
Thank you, Joe, ma'am.
Thank you, sir.
Hope to visit to you next program in some other resource person. I think I think you took part in Geeta's session. Right?
Yes, sir. Yes, sir. Yes, sir. Thank you so much. Thank you so much for remembering, sir.
Yeah.
What I would say is, can there be some kind of changes that we can look at?
Okay.
I'm not going to look at changes in the law, because when you want changes in the law, amendment, it's going to take donkey's years. Okay.
Yeah.
But could we have, like I said, you have introduced things like creche, you have introduced things like psychological counseling. You have got counselors who come in. Is there any way of upgrading these things? I know I shouldn't complain, but we have had psychological counselors where the counseling session comes for parties once in 3 months.
3 months.
You can't. You can't have psychological counseling. And then if the counselor has gone away, we had only one counselor. She was abroad for 6 months. So the cases were piling up. You can't have that. You will have to see that you've got qualified counselors of reputed standing, who are willing to give their time. Because you've got great counselors here. No. I'm not saying anything about the counselors in the family court. But maybe what you should do is to take the counselors out first, give them a training, sensitize them, and then bring them in as counselors.
Yes.
At one time, we had rotation of counselors every 3 months. So you have one counseling session. After 6 weeks, another counseling session. The next counseling session, you've got a new counselor. So you start from square one again. These kind of things. Then there is also the question of if it's going to be a permanent job, then what kind of counselors are we getting? What quality of counselor? I think if you could say that this is a sensitive posting, so you recruit the best, you send them for training, you sensitize them as you're going to sensitize the judges, you sensitize them, and then you bring them in and see how it works before we can do anything. And of course, you said sensitize judges, especially for, cases, different cases.
Yeah. And more importantly, what's your advice or suggestion to lawyers who practice on this custody jurisdiction or matrimony jurisdiction?
I think I've kept two important factors in my mind. One is, I've already told you, when it's a custody issue, think about the children. The client can be the mother. She's got the child and she can be my client. But I do try and talk to her saying, listen, it's good for your child to have access to the father. How can we give access, protecting the interest of the child? Don't say, give. How shall we protect the child when we give? That's a good point to start with.
Okay.
Lawyer, as such, we should not identify and say, no, my client wants custody. So I will fight custody tooth and nail. When it involves a child, let us see whether we can work. It's very difficult because your client should also be willing. You have to work. When you practice in the family court, I think I've had one fixed idea in my mind. That is, when a couple enter the family court, believe me, nobody wins, nobody loses. They are both losers. They have lost out on life and they have come into this court. Let's not take it as how long can I drag this case? How long can I prolong it? Let's see whether we can settle. I think about 90% of my cases are always settled. If
That's
you
good.
could say they're both losers, let's see whether we can work out something that is acceptable. I'm not forcing them.
Mm.
Is it acceptable? Can I work on the mind to make it acceptable? And I'm sure we can make a difference.
That's
Not
brilliant.
being adversarial. You have to first put your mediation cap, your cap to settle, and then see if it doesn't, then put that aside, put your adversarial cap on and start fighting.
That's in the final stage when everything is deserted to
Yes.
unfail.
Yes. If it's not settling, then of course I'm going to fight. I'm definitely not giving in.
And I have one more gray area where I think I want to ask you some suggestions. The mediation centers.
Yes.
Court offered mediation, court sponsored mediation. I'm appealing to know that the mediation outside the court has not picked up any momentum. We are still having only court sponsored mediation center and court sponsored arbitration only. And in such a situation, the mediators appointed by the courts, they are not fully equipped with such a kind of custody dispute at least. We have been fairly successful in mediation system in Madras, High Court, Madurai bench. But I am not fully happy in the way in which the custody matters are being handled by some of the mediators.
Then put out a requisition, sir. Ask the mediation center to get sensitive lawyers, mediators, to train them. I have also worked with mediation. I think I've come to Madurai and trained a lot of lawyers for mediation also. But I think mediation training should be an ongoing training where you keep on reminding the mediators how to approach it, because everybody settles down into one routine. And like you say, that if you could get mediators to be trained continuously by good trainers, I'm not complaining about trainers, but trainers, and then have special training for mediators who do custody cases. Maybe you should. You see, these are the kind of, your webinar series have been going, but if you could move and bring changes into the law system, into the system like this, I think it's a great series that you have done.
Thank you. Thank you very much. And one Maggie advocate wants to talk to you.
Yes.
Maggie, you can unmute and talk to Sheila, ma'am.
Yes. Good afternoon, ma'am. Good afternoon, ma'am and sir. Madam, very nice, informative your lecture, madam. If you permit, shall I ask my question in Tamil, madam? You can explain.
Kelma, Tamil Kelma.
Okay. Madam, family court la வந்து நான் ஒரு custody case வந்து ஹேண்டில் பண்ணிட்டு இருக்கோம். அது முடிஞ்சு போனது அந்த கேஸ். அதுல என்ன ஆச்சு அப்படின்னாக்கா, இப்போ குழந்தை பிறந்ததுக்கு அப்புறம் அந்த டெலிவரிக்கு அந்த ஒய்ஃப் வீட்டுக்கு வந்ததுதான் யாருமே அதுக்கப்புறம் ஹஸ்பண்ட் சைட்ல இருந்து யாருமே பார்க்க கிடையாது. ஒரு 4 இயர்ஸ்ல வந்து மியூச்சுவல் போட்டு அவங்க 2 பேரும் பிரிஞ்சிடுறாங்க மியூச்சுவல்ல. ஸோ சைல்ட் கஸ்டடி வந்து ஒய்ஃப்க்கு கொடுத்துடுறாங்க. ஸோ அந்த லாஸ்ட் டே ஆஃப் எவிடன்ஸ் வந்து ஹஸ்பண்ட் வந்து கேட்கிறாரு, ஐ வாண்ட் டு மீட் மை சைல்ட். கேன் யூ ஹியர் மீ மேம்?
can hear you.
நான் வந்து
பார்க்கணும்னு சொல்றாரு.
பார்க்கணும் அப்படின்னு சொல்றாங்க. அப்போ அந்த ஒய்ஃப் வந்து மதர் வந்து என்ன சொல்றாங்க அப்படின்னாக்கா, நியர்லி 4 இயர்ஸ் ஆயிடுச்சு, என் குழந்தைங்க வந்து அப்பான்றது யாருன்னே தெரியாது. இந்த லாஸ்ட் டே இவர் வந்து பார்த்துட்டு போயிட்டாருனாக்கா அது ரொம்ப எமோஷனலா பாண்ட் ஆகும். ஏன்னா இன்னைக்கு மேல நாங்க அவங்க தேர் கோயிங் டு செட்டில் இன் அப்ராட். அந்த ஆளு வேற ஊருக்கு போயிடுறாங்க, இந்த மதரும் வேற ஊருக்கு போயிடுறாங்க. அப்போ அந்த மாதிரி ஒரு எமோஷன் அந்த குழந்தைக்கு வந்து உருவாகும். அதனால வந்து இது நான் வந்து பார்க்க விட மாட்டேன் அப்படின்னு சொல்றாங்க. ஸோ இந்த மாதிரி சுச்சுவேஷன் வந்து அந்த எமோஷன் பாண்டை வந்து நம்ம எப்படி எடுத்துக்கிறது? அந்த குழந்தைய அந்த ஃபாதர் கிட்ட காமிக்கணுமா இல்ல வேண்டாவா?
Difficult question. Can I translate it? Ujwala and others who are not familiar with Tamil, do you want me to give a small synopsis of that in English? Or can I go ahead and answer it?
I think your answer in English should be better, ma'am.
English, okay. Then the facts will come out. The wife went for her confinement, never joined her husband again. When the child was 4 years old, they've come for a divorce. Mutual consent, everything settled, custody to the mother. And the very last day, the father wants to see the child. Now, Maggie, and the ஒரு நாள் தான் பார்க்கணும்ன்றாரா அல்லட்டி visitation rights கேக்குறாரா?
Hello, ma'am.
ஹஸ்பண்ட் ஒரே நாள், அந்த ஒரு நாள் தான் நான் புள்ளைய பார்க்கணும்னு கேக்குறாரா?
ஆமா ஆமா, அவருக்கு கஸ்டடியில வேண்டாம்,
விசிட்டேஷன் கேக்குறாரா?
no he prefers for the another marriage. ஸோ அவர் இது வரைக்கும் என் சைல்ட பார்த்ததில்ல, நான் பார்த்து பேசணும், சம் கிஃப்ட்ஸ் வந்து அவங்களுக்கு கொடுக்கணும் அப்படின்னு சொல்றாரு.
அந்த ஒரு நாள் மட்டுமான்னு கேக்குறாங்க மேடம்.
எஸ் சார்.
ஓகே.
அது அவ்வளவு கஷ்டமாமா காட்டுறதுக்கு ஒன் டே. Is it going to make that? No. I mean, அது முதல்ல you can talk to the husband. அவரை கொஞ்சம் கவுன்சில் பண்ணி கன்ஃபியூஸ் பண்ணாதங்க child. The child is going to think he's some uncle, not the father.
அவர் சொன்னாரு, இல்ல நான் ஃபாதர்னு சொல்லுவேன்னா my child wants to know me. அத சொல்லிட்டாரு அவர் பர்టిక్యులரா. சொல்லிட்டு நாங்க வந்து பேசிருக்கோம், என்ன பேசிட்டு கடைசியில மதர் மேல மிஸ்டேக்ஸ் இருக்கு, அந்த மாதிரி ஒரு பேட் இம்ப்ரெஷனை வந்து மதர் மேல சைல்டுக்கு அவங்க உருவாக்கிட்டாக்கா அப்புறம் நாளைக்கு பிரச்சனை ஆயிடும் அப்படின்றதுக்காக நாங்க ஜஸ்ட் அலோவ் பண்றோம் அப்படின்னு தான் சொன்னோம். ஆனா அந்த மதர் வந்து பர்டிகுலரா இருக்காங்க, வேண்டாம் பார்த்தா அவர் என் மனசை கழிச்சிருவாரு. இந்த நிமிஷம் வரைக்கும் நான் ஈவன் போட்டோல கூட காமிக்க கிடையாது என் சைல்டோட ஃபாதர் யாரு அப்படின்னு சொல்லிட்டு.
அது சொன்னா when we take this Maggie, there's two aspects for it. Can you bring up a child saying that he's never had a father or she's never had a father? I don't know whether it's a girl or a boy, but whatever it is, doesn't every child need a father figure?
Yes.
Somewhere there is a father. At some point of time, when that boy or girl is 15 years old, 14 years old, they are going to say, who was my father?
அந்த டைம்ல வந்து அவங்க they have a maturity, so they can understand madam. But இப்போ வந்து ஒரு 4-year child, because she is also plan to get another marriage. அப்ப அவ வந்து அவனுங்களை தான் ஃபாதர்னு சொல்லி காமிச்சு வச்சிருக்கா. இனிமேல் அந்த சைல்ட்
so it is not. So what are we looking at? We are not looking at the welfare of the child. At how comfortable the mother is going to be. She is going to get married again and she is going to tell the child that that man is the father. When the child is 20 years old, when the child is 15 years old, somebody says, hey, that's not your father. Your father is somebody else. You see what happens. You see in the world today that even children who are adopted go searching for biological parents when they're, yeah? So there is some deep-seated human instinct which says, I want to see my biological parents. There is something there. So I don't know. I think, Niga, what you should have done is to send them both for counseling before you could settle this issue.
எல்லாமே முடிஞ்சது. என்ன அட்மோஸ்ட் அந்த சைல்டோட வெல்ஃபேர்க்காக நாங்க அவங்க ரெண்டு பேருமே ரீஜாயின் பண்ணணும்னு தான் நிறைய ட்ரை பண்ணோம் மேடம். both are adamant. He is also going to he is staying in Malaysia or something and she is going to Finland somewhere. அப்போ அவங்க அதுதான் சொல்றாங்க, என் சைல்டுக்கு வந்து தெரியாது ஃபாதர் அந்த ஒரே ஒரு நாள் தான் பார்க்க போறாரு. இது வரைக்கும் அந்த குழந்தை பிறந்த 4 yearsல ஒரு ஃபோன் பண்ணதுல பார்த்ததுல பேசினதுல எதுவுமே தெரியாது. அப்ப அந்த மதர் சொல்றாங்க, அவளு சிங்கிள் பேரண்டா நான் மட்டும்தான் வளர்த்திருக்கேன், இனிமேலும் அந்த குழந்தையோட வெல்ஃபேர்க்காக தான் நானும் மேரேஜ் பண்ண போறேன். சோ அவளுக்கு அது தெரிஞ்சிருச்சுனாக்கா இந்த சின்ன வயசுலயே வந்துட்டு ஒரு கன்ஃபியூஷன் வந்துரும், அவர் ஃபாதரா இவர் ஃபாதரா அப்படின்னு.
I understand. The whole thing is based on the mother's perception. She's going to marry a man and go to Finland. So she doesn't
maybe want... that may be happen, may not be happen, madam. That is
okay. Later. Whether it happens or it doesn't happen,
yes.
Whatever it's that's what I said. When the custody case comes up, the person who's got custody tries to manipulate everything. He must not see the child, because the child, I may take the child and go out, I may get married, I want her to, so it's got nothing to do with the child. It's got everything to do with what the mother finds comfortable for herself. But so what are you doing? You're basing the whole situation on the right of the mother. The mother feels she's got a right. Whereas, what you are saying, because I've got a request saying, please answer in English from Ujwala.
No problem, I can understand.
So I'll answer in English, Maggie. The thing is, once again, you are not going into what is best for the child. That I said, maybe they should have gone to a counselor, to somebody who is a trained counselor outside of the court, a child counselor, a child psychologist, somebody like that, so that you can do this. You can't, I don't know any of the other facts. So I can't give you a watertight case of saying, yes, you should do this or you should do that. And anyway, there's no one rule or one way for everybody. Each couple has different priorities, different ways of fighting, different everything. So the answer has also to be different for different people. But when this is the question, it is the child does not have a problem. The mother has a major problem, and the father also has a problem. He may have let his wife and daughter go if he didn't know that she was going to marry again.
Yes.
It's because she's going to marry again, he's got to put some spoke in the wheel, most probably. I don't know. Let me not jump to conclusions. But the best thing I would advise is go to a child psychologist. What is the best thing for this child? When a third party professional gives advice, then maybe the parents would accept it. Okay?
Okay, ma'am. Thank you, ma'am. Thank you so much, ma'am.
Exactly the same thing happened in my office. There is a couple who are divorced. The child has not seen the father. The father and mother separated when the child was conceived. Now the child is about 21 years of age. He is a citizen of US by birth. After 21 years of the divorce, he called me last month asking for the details of the matrimonial proceedings. What was the allegation the father against my mom in the petition? Was my mom very meticulous in defending the case? What was the evidence produced by my mom in the case? Who was at fault? Don't I have the right to see the papers? I will come to India very shortly. Just give me a paper. I want to go through the papers. I want to know who is at fault. I am sure that my father was not so bad as my mother projected. He said, please arrange. I want to meet my father. After 21 years, that will happen to this girl also.
Sometimes when a mother comes to me and says, I will never show the child, I cannot do. Okay, if he goes to the father, totally spoiled, finished, his life is over. But if you hadn't fought with your husband, the husband would have been there with him and the child's life would not have been spoiled. Secondly, what I usually tell them is, don't fight a custody case as if what matters is till the child is 18. The child, this child is going to be your child when you are 80 years old and he is 60 years old. Lay the foundation now. Don't totally cut away. Let them be. And above all, especially if a child is 8, 9 years old and you say, never see the father, the child grows up with the glowing image, like you say, this boy, a glowing image of a father whom he's never known. You see, the father has got his own faults. We don't know what faults the father had. But in that child's mind, the father is perfect because he's not seen any faults of the father. You see? So I always say, keep a perspective that this child is your child for the next 50 years, next 40 years. Don't concentrate on these 6 years or 8 years, between 8 and 18, between 10 and 18. That's not life. It's much, you have to paint, as a lawyer, you have to paint a broader picture because they are, narrow and focused on only today.
Yeah. I could find one text from Advocate Vasavi. She had written, I have known a boy who was brought up without knowing his father. And subsequently, when he could not see his father as he died, he resented his mother his whole life.
Yeah, I agree. That's what we are discussing right now. That's what we're discussing right now, that they should have equal access. If not equal, they must have. In my mind, it's very clear that they must have some access to the other parent. Otherwise, it is something that is detrimental to the interest of the child.
Absolutely, ma'am. Absolutely. I think we are coming to the end of this session. Wholeheartedly, without exaggerating a single word, I thank you, ma'am, for the beautiful way in which you have taken to us to the nook and corners of this very sensitive subject, custody, where people fight on their selfish interest. People fight on the base of the ego, forgetting for a moment that it is only the interest of the child that counts. And it is only the custody of the children that is very important. You have highlighted the point well, and with minimum landmark cases. I think the whole session was enthralling. I thank you for the wonderful time. And once again, I thank you. And we'll come to you for some other similar webinar in the future.
Thank you, sir.
On
It
behalf
was a
of myself,
pleasure. And I hope people found it, useful. Thank you.
exactly. The prices are just for what's called pouring in my WhatsApp.
Thank you, sir.
Thank
Okay.
you. Thank you very much. Yeah.
Thank you.
Thank you.